The estate is not yet ready to be closed. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the use of the Notice of Continued Administration form. This is a SCAO form, State Court Administrative Order Form, PC 587. The PC stands for Probate Court. This form is readily available by doing a Google search, or you can contact my office, and we're happy to provide one to you for free. This form is guided by a statute and court rule, like all of the state court administrative forms. At the bottom corner where I've got the floating arrow, you'll see that it references MCL 700.3951. That's 700.3951. This particular statute applies to probate administrations. So let's think about the timeline. An estate is open and a letter of authority then gets issued, either through a court hearing or maybe by the court register. But there's a letter of authority beginning date, the beginning of the administration, the beginning of the powers of the personal representative to act on behalf of the estate. That date triggers a one-year timeline to conclude the administration. Now, of course, many times the administration of the estate lasts well beyond 1 year. I'll give you some examples. An example would be you're selling real estate, and it takes a long time to get the house ready, to list it, to get it sold. The estate may take well over a year to administer it. In addition, litigation involving an accident case, a wrongful death case, or disputes within the administration of the estate. All of these are reasons, or just a few reasons, upon which the estate may last well beyond that 1 year time frame. So what happens? Well, the statute says that if within that time frame the personal representative has not filed a sworn statement to close, or the summary closing statement, or a petition to close the estate, then there's a time frame upon which they must file this particular form. That time frame provides for 28 days from the anniversary date. Now, if you fail to do that, then the court can trigger a deficiency, and within 63 days thereafter can start suspending or closing administratively the probate estate. So for many reasons, it's critical that you follow and you calendar that time frame to ensure that the estate never lapses, to ensure that the personal representative's responsibilities never cease, or that there's no suspension, additional cost to reopen, and so on. So filing this form is not particularly complicated. It's just a step that's a requirement to do. Let's work our way through the form. At the top, you'll see that the county is referenced in blue. Simply identify the county in which the probate court is pending. In the top right corner, there's a case number. Pretty simple. Identify the case number in the top right corner and the estate name for purposes of the probate administration. The subsection 1 provides of the original date of appointment. So this isn't the date that you filed the original petition or application for probate, but rather when the personal representative qualified and became the personal representative with a letter of authority issued. That's the original date. So, and if it's 2 or 3 years down the road, you still have to go back to the original date of appointment in subsection 1. The first checkbox applies that this may not be the first time you've done a notice of continued administration. So for example, if it's year 2 or 3 or 4 and so on, you check that box. The second checkbox speaks about the fact that the estate was reopened, and there was a reopening date, and there was a new personal representative, or maybe the original personal representative that got appointed on a new date. So this is to clarify when a letter of authority for the origination date occurs, the estate gets closed, and then a subsequent letter of authority is issued on a different date. So that begins the new calendar year date. And it's really important to identify that date so that you can appropriately calendar it in your system. The next section identifies that the estate remains under administration, meaning there's more work that needs to be done. And then you're required under the statute to identify the basis for doing so. So as I mentioned, maybe it's continued litigation, maybe you're waiting on a tax clearance, the sale of realty, whatever it may be, you identify it here. This gives the court and the interested parties within that probate administration an understanding why the personal representative has not yet concluded the administration. Now, sometimes we've seen that a personal representative just keeps the estate going on, and they really have no intention of bringing the estate to a completion or to close it out. For example, the personal representative is living in the house upon which the estate needs to sell it, and they just have no incentive to move the estate forward because they don't want to leave the house. Well, when you receive this form, this continued administration, it is also, you have the right to object. You have a right to claim that the personal representative is not administering the estate under a reasonable time frame. So the personal representative doesn't just have full discretion and to administer the estate in any way they choose, but rather, if it's unreasonable, you can of course file something to say, Judge, this person is abusing the process, breaching their duty to the interested parties. We'd ask the court to remove that personal representative for these reasons. But generally, in most scenarios, there is a good, valid reason, and you identify it in this particular section. Subsection 3 identifies if there's been any changes in interested parties. That could be you as the personal representative or any of the interested parties within the estate. You have to identify them here or on an additional sheet to ensure that you give notice to those parties and for the court to update the interested parties within the court file itself. Below that section, there's a place for the personal representative to sign it and date it. And then if there's an attorney involved, for the attorney's information and signature. Now, once this form is completed, it needs to be filed with the court timely under the statute, and that will then trigger another year, assuming the court has no objection to the filing and the continued administration of the personal representative. Now, often we get calls because the letters of authority were issued in 1 year and somebody continues to file notices of continued administration. But the letters of authority continue to have an expiration date that has now lapsed. Well, once you file the notice of continued administration, you can ask the court for an updated current letter of authority with a new date on it so that if you need to present that to a financial institution, a court, or otherwise, you've got a current letter of authority that shows that it has not been expired. But the mere filing of this document and the acceptance of it by the court triggers a rollover for another calendar year. And again, it's not a calendar year from the date of the notice of continued administration filing, but rather from that original date, or if the estate had been reopened from that date, it'll continue 1 year, 1 year, 1 year. A real critical document to ensure that the estate remains in good standing and that it doesn't get closed or terminated. At the Probate Pro, we are passionate about everything probate. If you have questions about the notice of continued administration or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.